Police took $50,000 from him. He was never charged with a crime. Never arrested. Never even given a ticket. And it was completely legal. This is how law enforcement can steal your property and why almost no one gets it back. In 2016, a man named Phil Paramovic was driving through Wyoming with $50,000 in cash. He had saved for years to buy a music studio in Wisconsin. But during a routine traffic stop, a state trooper asked if he was carrying large amounts of currency. Phil made a fatal mistake. He told the truth. The trooper called for backup. They searched his vehicle and found the cash. Right there on that empty highway, they took every dollar. Phil asked what crime he committed. The answer? None. But here is where it gets strange. The police did not charge Phil with anything. Instead, they filed a lawsuit against his money. You read that correctly. The case was not Wyoming versus Phil Paramovic. It was Wyoming versus $50,000 in United States currency. And that distinction changes everything about how justice works. This legal mechanism is called civil asset forfeiture. And it operates on a principle that would sound absurd if it were not actually law. The government does not need to prove you committed a crime. It only needs to establish probable cause that your property was involved in illegal activity. Think about that for a second. If this is already making you question everything you thought you knew about American law, hit that like button. The burden of proof flips completely. In criminal court, you are innocent until proven guilty. But in civil forfeiture, your property is guilty until you prove it innocent. And proving innocence costs money. Legal fees can exceed what was seized. So most people simply walk away. In 2014, law enforcement agencies seized over $5 billion through forfeiture. More than burglars stole that entire year. The people sworn to protect property were taking more than criminals. But let me put this in perspective for you. Civil forfeiture was never supposed to work this way. It originated in maritime law dating back centuries. If a ship was used for smuggling, authorities could seize the vessel even if the owner was overseas and could not be prosecuted. It was a practical solution for a specific problem. Fast forward to 1984. The Comprehensive Crime Control Act transformed forfeiture into a weapon in the war on drugs. And here is what nobody expected. The law allowed police departments to keep what they seized. Suddenly, there was a financial incentive to take property. Departments could fund equipment, vehicles, even salaries through forfeiture proceeds. Some agencies became dependent on it. By 2001, forfeiture revenue had grown 1,200% from pre-1984 levels. A legal tool became a profit center. Now imagine you are a highway patrol officer. Your department needs new equipment. And you have the legal authority to seize cash from anyone you pull over. All you need is probable cause. What counts as probable cause? A large amount of cash. Nervousness during questioning. A car that smells like air freshener. Traveling on a known drug corridor. Which is essentially any major highway. The Institute for Justice documented case after case where innocent people lost everything based on these flimsy justifications. A church secretary lost $53,000 she had withdrawn to help rebuild her congregation. A college student lost $11,000 in tuition money. A restaurant owner lost $17,000 in cash deposits. None were charged with crimes. None were given their money back without years of legal battles. And this brings us to a question nobody can answer satisfactorily. How do you prove your money is innocent? But that is not even the worst part. Because there is another mechanism that makes this system nearly impossible to challenge. It is called equitable sharing. And if you have made it this far, subscribe now because what comes next will fundamentally change how you see law enforcement. Here is how it works. Even in states that have reformed civil forfeiture laws, local police can partner with federal agencies. They transfer seized assets to the federal government. The feds process the forfeiture under more permissive federal law. Then they return up to 80% of the proceeds to the local department that made the seizure. It is a loophole that renders state reforms meaningless. In 2015, the Department of Justice temporarily suspended equitable sharing. Forfeitures dropped dramatically. Then the program resumed. And the seizures came right back. The pattern was undeniable. And this is where I need you to pay attention. Because the courts have weighed in on civil forfeiture. And their decisions are a mixed verdict. In 2019, the Supreme Court ruled unanimously in Timms v. Indiana. Excessive fines are unconstitutional under the Eighth Amendment. This protection applies to state forfeitures. Tyson Timms had his $42,000 Land Rover seized after pleading guilty to selling $400 worth of heroin. The court said that was grossly disproportionate. A landmark victory. But here is the twist that changes everything. The ruling did not end civil forfeiture. It just said seizures cannot be excessive relative to the offense. Police can still take your property without charging you. They just cannot take too much. Drop your prediction in the comments. Do you think this ruling actually changed anything on the ground? So where does this leave ordinary Americans? The Institute for Justice grades every state on forfeiture laws. Only 7 states require a criminal conviction before assets can be permanently forfeited. Only 3 states have abolished civil forfeiture entirely. New Mexico, Nebraska, and North Carolina now require criminal charges. Meanwhile, 30 states still allow forfeiture without any criminal conviction whatsoever. And here is the revelation that brings this full circle. Remember Phil Paramovic? The man who lost $50,000